with the Committee on Open Government. He is the expert when it comes to freedom of information here in New York State. He's on the line right now. Bob, good morning.
Good morning. How are you? Spring is here. I heard you.
Spring is here. It's now official. What
did yard work. I'm a little bit sore, but that's okay.
Apparently, they're picking stuff up at the curb because everybody's got their bundles, their piles of old sticks and branches sitting at the curb. So that's a good sight to see, I feel, anyway.
I agree.
Okay, so I wanted to start with the mugshot issue.
Yeah, you made a mistake this morning. Did you know that?
I make several, but...
you referred to mugshots being available under the U.S. Constitution.
Well, that's my question.
I don't think so. I don't think so. The Freedom of Information law is statutory. Mm-hmm. And in most instances, there's no right, a constitutional right of access to government information. The only instance in which arguably that is so would involve the right to attend a criminal trial. And in fact, that does relate to mugshots, and we had advised for years, and the court agreed with us, that since we can see somebody's face during a public judicial proceeding, the mugshot is public, at least for a time. And I say for a time because if any one of us is charged with a crime and the charge is dismissed in our favor, the records become sealed.
Right.
The records become sealed.
It is interesting to see what occurs here is with the web. That's the new problem because this stuff just lives out there forever and ever. Absolutely
true, and that is the problem. That is the problem. Once it's out there, for all we know, it could be in cyberspace forever. But realistically, that's true of any number of kinds of records. Maybe they're true, maybe they're not. In some places in the world, there's a movement to remove items that may no longer be relevant or that may be inaccurate. How that occurs, I'm not a techie, I don't know. But there's been a lot of misinformation, in my opinion, that's been put out regarding access to the mugshots.
You think I'll get the clarification here, but you fall on the side of it's only allowed because state law allows it. So if they do pass a law that says it's not allowed, would you agree that mugshots are not allowed?
If that's what the law said, but that's not what the law says.
Right. Okay.
In fact, I've read so many articles referring to a ban on the disclosure of mugshots. That is not true. That is not true. The Freedom of Information law contains an exception dealing with the ability of government to withhold when disclosure would result in an unwarranted invasion of personal privacy, an unreasonable invasion of privacy. And the law contains a series of examples of unwarranted invasions of privacy, one of which now deals with mugshots. But the provision doesn't say that records must be withheld. It says that records may be withheld.
Right.
And that's typical of the exceptions in FOIL. We can choose to disclose mugshots if we want to. And that's pretty much what this new provision says. In fact, I have it in front of me. It's very brief. It says that an unwarranted invasion of personal privacy includes, and I'll quote, disclosure of law enforcement arrest or booking photographs of an individual unless public release of such photographs will serve a specific law enforcement purpose and disclosure is not precluded by any state or federal laws. Well, in the city of Utica, for all I know, they could establish a policy of disclosing mugshots based upon their belief that disclosure does serve a law enforcement purpose.
And that has happened. The Oneida County Sheriff's Department has said that based on that word may, they will continue to release mugshots as they see fit.
Well, I think that that's wise, and FOIL has always provided a degree of flexibility, and this provision, it seems to me, is proof of that. I've heard from many sheriff's offices and other law enforcement agencies who have in the past disclosed mugshots, and generally speaking, will choose to continue to do so.
The sheriff, we had him on this morning, and he also said, he might have said this last week, but we were talking about it today, and basically to the point you made about specific purposes, he said, we've had a policy for a long time. It deals with public safety, so you know who your neighbor is or you know the guy who just moved in down the street is, and it deals with transparency of my own department. Do you agree with him?
You know, law enforcement agencies want to be able to tell the world that they're doing their jobs well. And one of the ways that they do it is by sharing information regarding booking records, information regarding arrests, as well as mugshots. And, as a grandfather with grandchildren right in my neighborhood, gee, I think we want to know if a neighbor has been arrested for whatever it might have been.
Yeah. I do feel like, for instance, the pedophilia or sex crime list, any of that stuff, I think it's extremely important to be able to know what those people, what they look like. I think it is important.
Well, I think a lot of people would agree with that conclusion.
Yeah.
Let me ask you on the other side. Do you have an opinion on this? I mean, this happens all the time. Someone gets arrested, charges are dropped or dismissed because it's a case of mistaken identity. There is the element of, and I think the governor had argued this, where you get a public conviction without a legal conviction. Do you have a thought on that, where someone's picture's out there, says they did something horrible, but in actuality, maybe they did, maybe they didn't?
I agree with the governor's point of view in general, but again, it's part of society these days in the era of the Internet, and it arises in any number of situations. And to my mind, rather than attempting to change the law regarding public access to government information, I think it would be better to go after the companies that have essentially extorted money from people who have been exonerated.
Yeah, right, because that is happening a lot.
And
that's
they
a real
passed a law
problem.
of that nature in California.
Yeah.
They go after these companies that are hurting people unnecessarily.
I want to take a caller who's, by the way, it's 315-736-0186. Mike is on in Rome with a question about mugshots. Mike, you're on with the known, this is Bob Freeman. So what's your question?
Hi.
Well, actually, he could just kind of comment on it. I fully agree with the mugshots upon conviction. It's, the problem is someone gets arrested, their mugshots out there forever, and then they're found to be not guilty or, they were, charged wrongfully, and then you Google somebody's name and there's the mugshot.
Yeah.
So he had just spoke on that, but, that's my take.
Oh, that was your question. So, all right, fair enough. Okay, Mike, thank you.
Thank you.
All right. I want to ask you about I know there was just recently a court ruling regarding body cams. And, for instance, we have a situation where a political candidate here who was arrested on charges of domestic violence, it turned out after time went on, the female no longer wished to cooperate with authorities. After that happened, obviously charges were dropped. They didn't have a witness. But in the midst of all of that, there is a body cam video available. This is someone who's running for public office. We have foiled to get that. Recently, there was an appellate court decision that said that is foilable, and it is the right of the public to be able to see that body cam footage. What are your thoughts on our chances of seeing that body cam? Oops, hold on.
The sin of oversimplification. The body cam footage is simply another kind of record.
Yeah.
And whether it's public or not is dependent upon its content. If the body cam footage involves a police officer interviewing a witness to a crime and disclosure would place that person in jeopardy, certainly there's a basis for withholding.
Yeah.
If disclosure of the body cam would interfere with an ongoing investigation, there's a basis for withholding. But there are other situations in which disclosure of the body cam footage would be largely innocuous, and it may be available under FOIL. So, again, FOIL is not an all-or-nothing provision of law. It's a sometimes, or it's a shade of gray. It's not an all-or-nothing.
Can I ask your opinion on this, on the case Bill was just referencing? If charges are dismissed or dropped,
and the case is sealed,
does that impact how you feel about a body cam footage?
Of course. The body cam footage would relate to the arrest, and it would be among those records that would be sealed.
So, okay.
Well, let's see.
We'll see. We'll see what we hear back from.
I am flippant sometimes, and I refer to what I've come to call the Aretha Franklin principle of law. Do you know that one?
I don't, but
I can't wait to hear it.
I hope it involves some
Do
respect.
you remember the movie involving Aretha Franklin? Years ago, singing as a waitress behind the counter in a diner, singing, "You Better Think." And I think that the issue of body cams has been pushed pretty quickly without a great deal of thought being given to the impact of it. It costs a lot of money. The time that it takes to review body cam footage to determine what's public and what's not can be immense. And all of these issues they'll be figured out one of these days, but it's going to take some time.
It is interesting how Albany seems to move before we think. Before we think things out.
Sometimes it was the Blues Brothers movie. You're old enough to have seen it, Bill, I think.
Yeah, I believe that I am, so unfortunately. And then just quickly, so people know, what is the procedure? So you go forward and you present your FOIL to the municipality. What is the municipality's responsibility from that point forward?
Well, first of all, every government agency is required to designate at least one so-called records access officer. That is the person who has the duty of coordinating the agency's response to requests. From there, when the request is received, the agency has 5 business days to do something. If it's really easy, the agency can say, yes, come on in, we have it, or we'll send it to you, or the agency can say no. And if there is a denial, it has to be given in writing, and the applicant has to be informed of the right to appeal to the head or governing body of the agency or somebody designated to determine appeals. If more than 5 business days is needed, the agency must acknowledge the receipt of the request in writing within that time, and generally speaking, it can take up to 20 additional business days to figure out what's public and what's not, but any delay beyond 5 business days has to be reasonable based upon whatever the facts and circumstances might be.
In our case here, they're saying that we will be contacted with information about our request at least by 4/29.
Okay,
so
well,
that's
today's the 9th.
Yeah,
so that's 20 days. It's less than 20 business days.
Yep.
You know, the hope is that they can complete their review before that. That's generally a maximum kind of period.
Very interesting. And let's talk about the just before we let you go. The problem with the internet is that some of this stuff just lingers out there online, whether it be an arrest report or be a video that showed up. And even though someone might have been found that a case was dropped or found to be not guilty, that information still lingers out there. That is part of the problem, and I'm not sure how we solve that.
I don't know how we solve it either. But again, there are so many instances in which information is put out there that may be false. It may have nothing to do with an arrest. It may involve somebody's, who knows what, a health condition. It might involve any number of issues, grades in school. It's out there perhaps forever. And I've suggested, especially to young journalists and journalism students, we need truth tellers now more than ever before. More than ever before. Why? Because anybody out there can establish a blog or a website, and it's becoming increasingly difficult to figure out what's true and what's not.
Yeah. You're right. It is a real problem. My guess is you're all for the Mueller report being released. What are your thoughts on redaction?
You know, I certainly would not want to see grand jury information disclosed unnecessarily, but then again, Congress has subpoena power and can overcome grand jury secrecy. I think that we don't know nearly enough about the Mueller report. A 4-page summary written by his hand-picked attorney general, I think, probably has misled us in consideration of as much as we do know about this president. I'm guessing that there is a lot of information there that is not going to place him in the best light. Yeah.
One more before we let you go. Mitch and Ilian standing by. Give me about 20 seconds here, Mitch, no longer. Go ahead.
Okay, this happened to me, and here's the question. The village board in Ilion wanted to meet with me for a discussion, and they said, we don't want the public to know about it, so we're going to schedule a work session, not in the municipal building, but in the fire station. There will be no minutes kept. It will not be an official meeting, even though a quorum of the village board will be there.
Let me make this easy. Let me make this easy. If a quorum, a majority of the board, gets together to conduct public business, that's a meeting covered by the open meetings law. It has to be preceded by notice. It is supposed to be held in a place that will accommodate the public. I don't know what your issue was. I don't know whether there would have been a basis for going into an executive session. But even if there was such a basis, they'd have to convene the meeting open to the public. There would have to be a motion made in public to close the doors.
There you go.
That's what I thought, and they did not do that.
Oh, interesting. All right, Mitch, thanks, man. And,
okay, Bill. Thank you.
Okay,
Bye-bye.
And Bob Freeman, as always, you are the authority on freedom of information. We really appreciate it.
You're too good to me, and I appreciate the opportunity.
Thanks so much.